Hello everyone and welcome to the channel Contract Simplified. Today's video we'll be discussing about unification and harmonization of contract law. As you can see in the screen, I have shared the newsletter Contract Simplified and will discuss about A to Z of contract lifecycle management. You can subscribe to this newsletter in LinkedIn portal. I have posted the link in the description. In continuation to this particular video, we will be studying about unification and harmonization of contract law. The unification and harmonization of contracts comes to rule when there is involvement of international law or international trade laws. At many times, there will be conflict or overlapping. That is the situation wherein harmonization and unification comes to place. So what is harmonization of contracts? Harmonization is a broad concept that refers to bringing things together in accordance with the pre-established order. Harmonization in the legal sense entails bringing together legal rules from two or more legal systems to minimize the effect of differences between them. Harmonization, on the other hand, seeks to coordinate between different legal systems by eliminating major differences and creating minimum requirements or standards. Harmonization is the process of identifying and reconciling differences in legal systems and cultures to create instruments that standardize terms and practices of cross-border trade. As Professor Twitflenser explains, that harmonization can be accomplished in two ways. That is, by replacing existing domestic rules with an internationally agreed rule, or by supplementing domestic law with an internationally agreed rule applicable only to international dealings. In simplest words, it is the standardization of templates to create consistency and efficiency. Contract template harmonization is a great step in achieving that consistency within contract types, providing the same starting point in negotiation and a standardized language for clauses and provisions. It facilitates an easier maintenance, accelerated cycle time, reduced cost, and more time for lawyers to practice law. Here we'll discuss about two sample clauses. First one is, the parties shall, well appropriate, endeavor to work towards harmonization of their respective mandatory requirements, taking into account relevant international standards, recommendations, and guidelines in accordance with their international rights and obligations. Next clause is, the parties shall endeavor to harmonize their standards, including tests and certification procedures, in accordance with Article 3 of WTO SPF agreement. Third clause is, during both transactional and operational phases of this agreement, both parties intend to continue to participate in the activities of the Global Harmonization Task Force and utilize the results of those activities to the extent possible. Such participation involves developing and reviewing documents developed by the Global Harmonization Task Force and jointly determining whether they are applicable to the implementation of this agreement. So this is all about the harmonization of the contract. Next topic is standardization of contract. A standardized contract, also known as a standard form of contract, is an agreement between two parties where only one party sets the terms and the counterparty has little or no ability to change them. These boilerplate or take it or leave it documents are most common in business to consumer transaction and allow for the mass distribution of goods and services. It will be common for all the persons who avail the service or products. You would have experienced these standard contracts when you access any app or any websites or you purchase any insurance policies. Unification of contract. Unification also focuses on substituting or combining two or more legal systems and replacing them with a single system. The sample clauses. Unification. When an economically viable reservoir extends continuously to one or more areas outside the contract area, the contractor under agreement with XXX and the interested parties, subject to prior approval of the competent authority, implement a cooperative plan for unified exploitation nation subject to the provisions of Indian law. So this is all about the harmonization, unification and standardization of the contract. I hope you are now able to identify the difference between these two concepts. So before winding up the video, I would like to inform that I'm conducting a 1-month course on contract lifecycle management in association with Indian Institute of Industrial and Professional Studies, that is an ISO certified institute. Do let me know if you are interested in pursuing the course. If yes, please do comment below, or you can contact me via WhatsApp, wherein I'll be sharing all the details related to the course. Thank you for watching, and before going, please do not like, share and subscribe the channel. Thank you for watching.